Trusts. One way to hold ownership in real property is through a trust. Trusts are of two types: living and testamentary trusts. There are a few parties involved in a trust. Trustor, person conveying title to a trustee. Beneficiary, person benefiting from the trust. Trustee, person carrying out the trustor's wishes. An important advantage of a trust is to avoid probate, so trusts are used often in estate planning. When someone dies, often their estate must go through probate to ensure that the instructions of their will, if they have one, or the laws of heredity, if they don't, are fulfilled correctly. The process of probate can take up to a year or more before the property is dispersed to the heirs. A living trust is created during a person's lifetime and is often used when minor children are involved. The property may be placed within the trust for their use in their lifetime or when they reach the age determined by the person who creates the trust. In the meantime, the trustee will manage it for them according to the terms of the trust. A living trust differs from a living will in that a living trust is established to convey property, whereas a living will is created to dictate terms of care in the event the trustmaker becomes incapacitated. A testamentary trust is created according to the terms of the will of a deceased person. Unlike living trusts, testamentary trusts do not avoid probate. All trusts have three parties: the trustmaker, commonly called the trustor, the trustee, the person established in charge of carrying out the terms of the trust, and the beneficiary, the person who receives the benefit of the trust. To create a trust, the trustor usually conveys property to the trustee with instructions for how the trustee is to hold and manage it on behalf of the beneficiary. It's also possible to deed the property directly to the trust. These instructions are called the trust agreement. Once the trust agreement is executed, it's held privately and not filed with the court. Who receives a copy of the trust agreement is determined when the trust is established. Often the trustor and trustee will be the same person until the trustor dies, in which case the new trustee is named within the trust. In the case of a married couple, the spouses may transfer real and personal property into a trust and then name themselves as joint trustees with rights of survivorship. After the death of the second spouse, the estate is distributed to the beneficiary or beneficiaries named in the trust. The creation of a trust is a legal process that is best handled by attorneys. It's not inexpensive to establish a trust, but it can save money and a great deal of hassle in the long run by the avoidance of probate. The costs to maintain the trust include payment for the trustee for minimal fees and operating expenses. All estates must go through probate is false. Property held within a living trust avoids probate is true. A living trust is created during a person's lifetime and is established to convey property. Is true. A testamentary trust is created according to the terms of the will of a deceased person. Is true. Both living and testamentary trusts avoid probate is false. Beneficiaries aren't responsible for the cost of administering a testamentary trust is false. We trust you now know how a living trust differs from a testamentary trust. To summarize, a living trust is created during a person's lifetime and is established to convey property. A testamentary trust is created according to the terms of the will of a deceased person. A living trust avoids probate, while a testamentary trust does not. Land trusts. One form of trust is a land trust. A land trust is similar to other trusts except that it is formed specifically to hold real estate. Real property is the only asset within the trust. Usually the person who establishes the trust, the trustor, is also the beneficiary. The benefits of such an arrangement include privacy. The identity of the trust owner is not made public. This can be helpful, for instance, if someone wants to acquire several parcels of land without raising inquiries. Property can be purchased and held in the name of the trustee. In most cases, the trustee may reveal the trustor's identity without the trustor's permission if under court order or subpoena. Ease of conveyance. A beneficiary interest in the land can be conveyed without having to go through the formality of a deed. Beneficiary interest is considered personal property, even though the interest conveyed is in real property. Land trusts may be created at the time real estate is purchased or after it has been acquired. Under the trust, the owner, who is usually the beneficiary, directs a fiduciary, usually a professional such as an attorney or a third-party trust company, to hold title to the real estate and provides instructions for management and control of the trust during the trustor's life and for disposition upon the trustor's death. The trustee must abide by the scope of authority outlined in the trust agreement between the trustor and the trustee. Most land trusts are revocable, which means that the trustor may manage the trust, receive any income or other benefits from it, change the terms of the trust agreement, change trustees, or terminate the trust. Upon the trustor's death, however, an existing land trust generally becomes irrevocable, permanent. Land trusts generally continue for a specified term, such as 10, 20, or 30 years. The trustee must either extend the trust term when it expires or sell the real estate and provide the proceeds to the beneficiary. To summarize, a land trust is formed specifically to hold real estate. Real property is the only asset within the trust. Under a land trust, the owner directs a corporate fiduciary to hold title to the real estate for a specified term, such as 10, 20, or 30 years, and provides instructions for management, control, and disposition upon the owner's death. When the land trust term expires, the trustee must either extend the term or sell the real estate and provide the proceeds to the beneficiary.